Number 155, Justinian Capital versus WestLB.
If I could reserve 3 minutes, Your Honor.
3 minutes, sir?
Yes,
You
thank
may.
you. Jim Sabella for appellants. The decision below undermines the legislature's creation of the safe harbor for securities transactions in the Champerty statute. The statute simply provides that the safe harbor applies if the purchase price is $500,000 or more.
Looking at this safe harbor, it's somewhat on its face counterintuitive, right? So Champerty's bad, but if you do it on a large enough scale, it'll give you safe harbor. It would kind of be an odd statute, safe harbor, to apply to like insider trading, right? It's bad, but if you trade enough shares, you're good. So what would be the reason for the safe harbor the way it's written?
I think clearly the reason is to protect big financial transactions. New York, and this court, you know...
I think it's to say, given what Champerty protects against, that you have to have a stake in the game, right? And if you look at the legislative history of this statute, as I read it, there was a provision that they've tossed around that was debated to say face value, $1 million, which would have been your argument. It's a large enough transaction. But they didn't put that in the statute. They put the purchase language in.
Right, but
so doesn't that go towards you have to have a real stake in the game to do this?
Well, yes, I'll get to that, but I wanted to talk about that change in the statute because the statute had provided $1 million face amount or $500,000 paid, and use that word. And when the bill jacket talked about paid, it was referring to that version of the statute. But then when the legislature adopted the statute, they didn't adopt either of those things, and they simply said purchase price, and they didn't say paid. And I think there was, I think that meant something.
But
I
that
think
would be lowering the face value, essentially.
I didn't read it that way at all, Your Honor. And I think the stake in the game here is there's a binding obligation to pay.
Is that why they made the change in your view?
Well, I don't know. But I do think that is part of it. I think that a binding obligation is good enough. I mean, consider, like Your Honor was saying before, the rules you adopt have to apply to everybody here. Suppose this is Microsoft, and Microsoft promised to pay $500,000.
But let's go to the binding obligation to pay. I read the purchase agreement, and it seems to me if you don't pay the purchase price by a certain date, what you essentially have is an option to take an extra 5% of the recovery.
Well, I think it's more than that. You do lose 5%, right?
And that's your option. You could pay $500,000, or you could think, I'm going to recover more than that at 5%.
I don't see it that way, Your Honor. They have an obligation to pay that money. And recall, there's evidence in the record...
What happens, counsel, if they default?
If they don't pay the money?
Is there any provision in that purchase agreement that if they default, something happens? What happens?
Well, in addition to losing 5%, it's a debt. They could be sued for it. I mean, the uncontradicted testimony of both parties to the transaction.
But as I read that agreement, they can only recover the actual notes themselves.
I don't think that's correct, Your Honor. I think they could go against Justinian, and as Mr. Lowe testified, if they go against Justinian and put Justinian into insolvency, they could go against whatever assets Justinian has, and it has several other portfolios.
I thought they defined assets as these notes right in the agreement. Am I misreading?
Those are the assets if there's a default, but this created a debt. This is an unequivocal obligation to pay. And the testimony was very clear about that.
Some demonstration of a reasonable possibility that the entity can make good on its obligation to pay?
Well, sure.
What is that?
It is the borrowing power. I mean, they went into the market. And there was a prior deal, it's referred to in the papers, between Justinian and WestLB. And there they were able to borrow the money, and they paid the $500,000. I think it was actually $900,000, but they paid it. And here they went into the market again. They offered to give up to 50% of the interest to get that. But the motion to dismiss was made, and they couldn't borrow the money. But that doesn't mean that, you know, when someone offers to give up 50% of their interest, you don't do that if you don't think you really have an obligation to pay.
Isn't there at least a question of fact as to what they did or didn't do, and whether this is, you know, I'll use the word sham, or it's a legitimate obligation?
Those are questions of fact, and I don't think summary judgment was the answer here. I mean, we argued that in the papers, that there are a lot of issues of fact relating to that. but they did go into the market, and let's face it, every house buyer in America pretty much needs a loan in order to borrow the house. It doesn't make it a sham. It doesn't
Well,
make it illusory.
Analytically, though, you got to take a step back. First, you got to, even under what Judge Stein made reference to, is it is a Champertus arrangement. Then are you acknowledging that?
Not at all, Your Honor.
Okay.
Not at all.
Because if we're talking about a sham payment and whether it's a question of fact, then we say the safe harbor applies, or may or may not apply, depending on whether or not this transaction is an adequate substitute for payment. Maybe it is, maybe it isn't a question of fact, but nonetheless, it's still a Champertus transaction.
But I don't agree with that.
Okay.
And that's the second point. If we win on either of those points, there has to be reversal. We don't think it's Champertus at all. They bought securities. They bought a legitimate debt, and it seems to me if this Court's decisions in Bluebird and Love Funding mean anything, it's that if you buy debt and you try to enforce it, the fact that you may have to resort to litigation doesn't make something
Well,
Champertus.
what about the fact that, that they have a right to, that it's kept in this vault for them, and that certain decisions can't be made, transfers can't be made without their consent? I mean, does that look like really relinquishing ownership?
Again, that's not really what the situation is. There's an account, right? And the account is in the name of Justinian. There's no vault, there's no lockbox. That's something Mr. Paparella cleverly put in his papers, but there is no such thing. It's an account.
How much
And-
money are they making off this?
Excuse me?
What
Right now,
piece of this are they getting?
their share of the recovery would be, right now be 15%. It would have been 20%, but now it's 15%.
Which, when these parties are entering this agreement, what is anticipated to be the value of the 20%?
Well, that's why they did it as a percentage, because it's awfully hard to evaluate what's going to be collected on distressed debt.
And yet you're committing to $500,000?
Yes. Yes, Your Honor. I mean, they expected, look, there's no evidence in the record. Did they expect to recover 20 million or 30 million or 40 million on these notes? The notes are 180 million euros, okay? So that's the amount in controversy here. But
I want to go back a second before you get off on this.
Yeah.
Bluebird Partners talks about valid business reasons for the purpose, for the purchase, and there are various other reasons were given for it. I don't think that supports your argument that this is not a Champertus agreement. Secondly, Love Funding, I think, raises some more interesting questions, and you might want to address those, because there, the way I understand it, it was a pre-existing, the question was whether or not there's a pre-existing proprietary interest. But from our point of view, also the questions raised is whether or not a Champerty claim requires that the claim itself be illegitimate or prosecuted in an effort to get costs. And what's illegitimate and what's costs, of course, then come into meaning, and we're looking at our jurisprudence back to 1906, and the case that the second, Reitman, I think is the name of the case, I'm not sure. And, but it's an interesting legal question, but I think it directly affects what's considered a Champertus transaction.
Right. Well, with respect to the pre-existing interest aspect, that didn't exist in Bluebird. It didn't exist in the federal case, the Second Circuit's case, Elliott Associates. It didn't exist in Judge McKay's case, Bank Justinian against Paraguay. Purchases of distressed debt all the time don't have pre-existing interests, and the transactions are not held to be Champertus. And with respect to the fact that they have a percentage sharing arrangement, again, in Judge McKay's case, he specifically says the fact that you do this on a sharing basis doesn't make it Champertus. This court had the Fairchild-Hiller case, where 75%, I think, was going to somebody else. The court rejected both Champerty and real party and interest. So I don't think the fact that they weren't able to price it exactly, so they said $1 million plus a percentage, I don't think that in and of itself has really anything to do with whether it's Champerty.
So does Champerty require that the claim be illegitimate or prosecuted in an effort to get costs?
I believe so, and I think the amicus...
I'm sorry?
I said I believe so.
Do you?
And I think the amicus brief that Buford Capital put in sort of lays that out pretty well, that really what Champerty's involved with is it a shakedown just to try to get some costs. This is a legitimate 180 million euro distressed debt, and it seems to me that the Champerty statute really doesn't apply.
Thank you, sir.
Thank you.
Counsel?
Chris Paparella from Hughes Hubbard for the respondents, Your Honors. I want to take the issues, the questions that Your Honors raised in the order that you raised them. If you look at the Safe Harbor Amendment from 2004, and you look at your decision, Judge Pickett, in the Merrill Lynch versus Love Funding case, and the decision of Judge Bellicosa in the Bluebird case, all three of those things are on a continuum. And they express a similar philosophy about Champerty in New York, and that is that the crucial question under the Champerty statute is whether the party taking the assignment, buying, because there has to be a purchase, has skin in the game.
So what is required for skin in the game? A promissory note, would that be enough?
No, I don't think it would be enough, Your Honor.
It has to be cash paid, actual cash paid.
Your Honor, I believe that the legislative history shows that what the Assembly intended was a payment, was an actual payment.
Well, it may be a payment. What you talk about skin in the game, if you have a legal obligation to pay money,
Right.
Isn't that skin in the game?
First of all, Your Honor, there's no legal obligation to pay money here.
Well, there's a contract here. Now, you may question whether that is a sham or a legitimate contract, but let's assume for the moment that it is absolutely legitimate, that all the things that they say, that they tried to raise the funds, that they were still working on that, and that they weren't able to do it by the time that the statute of limitations ran out. But they absolutely intended, and there's ramifications if they don't pay this money. Let's just assume that.
Okay.
Why isn't that good?
Well, Your Honor, if you read the legislative memorandum from the Assembly, and there's some confusion here, there were two amendments making their way. There was one amendment in the Senate which had some language, and there was an amendment in the Assembly which used the word purchase price. And if you read the memorandum, what the Assembly said is that the purpose of the bill was to take a certain certain types of transactions out of the Champerty statute. And those were transactions where investors had actually invested, had skin in the game, had paid a substantial amount of money and invested in the note, and so having paid...
But if I sign a promissory note, okay, and again, I realize that this is not the exact facts we have here, and I put my house against it as security, I think that I have skin in the game, even though no cash has changed hands.
You may, Your Honor, and I would agree with you that if you do something like that, you're probably closer to the safe harbor than what they did, but they didn't sign a promissory note. In this case, they didn't...
They signed a contract, though.
No, but Your Honor...
How is a contract different from a promissory note?
I'll tell you how it's different, Your Honor. In the contract they signed, they admitted that the failure to pay the base purchase price isn't a default and it's not a breach. And so if
Where does it say it's not a breach?
It says it's not a default in the contract, and the negotiator for Justinian, the owner of Justinian, Mr. Lowe, testified in his deposition that the failure to pay the base purchase price was not a breach of the contract. He testified to it 3 different times in his deposition. I asked him, I said, is it a default? He said, it's not a default, and it's clearly, if you read the agreement, it's not a default. And I said, is the failure to pay it a breach? And he said, no, it's not a breach.
Counsel, it seems to me, going back to my original question, it's an option.
It's just an option, Your Honor. It's just an option.
So there's a payment date where they have to decide, are we going to pay or are we going to take a 5% piece of the recovery?
Exactly, Your Honor. Exactly.
To go back to a question earlier, the recourse here, I read the contract, and I think that's the contract, was against the assets and not against anything else.
Against the notes.
Right.
But
Those assets, sorry, yes.
You have to read Mr. Lowe's deposition, because I asked him in his deposition about, I took him to Section 3 of Section 10 of the contract, which is the remedies for breach. And I said, does it apply? And he said, no, because there's no breach. And I said, well, if there's no default and no breach for the failure to pay the base purchase price, then how do they enforce it? And he launches into this thing about, well, they could go down to the Cayman Islands and commence an insolvency proceeding.
Putting that aside for a second, so there is some language in this contract that if you don't pay, interest accrues, right, on the purchase price.
Yes.
But it seems to me, and I'm not entirely clear on this, that if you opt for the 5%, the interest is subsumed in the 5% recovery.
Yes, Your Honor.
Does
Yes,
it make
Your
any
Honor.
difference, in our previous decisions, we've always talked about stirring up litigation, and it's sham kind of stuff. And if I understand this right, the owner, DEPFA, didn't want to sue the German government or somebody, so they had a legitimate reason why they couldn't enforce these notes. So they go find somebody who can do it for them. That's not champertus in your view, is it?
It depends upon, I think what Your Honor said in the Merrill Lynch case is you have to look at the assignment and you have to look at the purpose of the assignee. What was the assignee in this for? Did they, for example, in the Merrill Lynch case, the assignee already owned the defaulted mortgage, and they took the assignment in order to enforce the rights that they already had. In the Fairchild, the Grumman versus Fairchild case, the assignee there was Grumman. They had bought the whole business, and they took the lawsuit as part of the acquisition of the whole business. And if you go to page 200...
You're not saying the statute turns on whether or not you've already got some interest.
I think it turns on whether no, not entirely. It turns on whether at the end, after the assignment is consummated, whether you have an interest, other than your ability to profit from the litigation. So either, like in a distressed bond case, Your Honor, you've bought the whole bond, so you own it lock, stock, and barrel. You have an interest in it, right? Here, that didn't happen. They didn't buy this lock, stock, and barrel. And let me just take you to the record, to one key part of the record. If you look at page 217 of the record, that's part of the contract, and it's a letter that Justinian writes to Canadian Imperial Bank of Commerce about what they're supposed to do and not do with the notes and all the associated rights. And what they instructed, they were required to send that letter to Canadian Imperial Bank of Commerce, and what they say to Canadian Imperial Bank of Commerce is, do not take those notes out of that account unless the seller, Deutsche Pfandbriefbank, gives you their prior written consent to do it. You are forbidden. We can't get them out. Nobody else can get them out. Deutsche Pfandbriefbank has a first lien, a perfected lien on those notes. They have to stay in that account unless they say something different. That's a lockbox account. That account is set up for the benefit of the seller, and they have the right to 85% of the proceeds. The only interest that Justinian has in this case is its right to a 15% contingent fee. They're not even paying the costs in this case.
But, so you don't agree that if they actually paid the $1 million?
If they paid the $1 million, Your Honor, they'd be in the safe harbor. But they
okay.
didn't. They didn't, and they never had any...
That's another question that we haven't gotten to yet, but...
Well, right. But, Your Honor, there's no dispute here. By the way, in terms of summary judgment, the key facts here are not in dispute. They never had the $1 million.
But to me, intent is almost always a jury question.
But, Your Honor, when you have...
Oh, and both of this really, to me, the arguments on both aspects of this case turn on intent. What was their intent in entering into this transaction, and what was their intent in putting this purchase price
Right.
in the agreement?
Your Honor, if you look at appendix, and I'm going to say the numbers backwards because it's an email string, so start with page 385 and work your way back to page 376. And it is a series of emails going back and forth between Mr. Lowe, who owns Justinian, this English-trained lawyer who lives in the Cayman Islands, and Mr. Glynn, who's the negotiator for Deutsche Pfandbriefbank. And what they agree is that the purchase price is not really a debt.
I don't read it that way. They clearly were trying to make sure that they got within the safe harbor. There's no question about that, but I don't read it the way that you read it.
Well, Your Honor,
They never intended to pay it.
Mr. Lowe says to Mr. Glynn that it's an option. If he wanted to pay it, he had an economic incentive to pay it, because if he paid it, it kept his contingent fee at 20% rather than 15%. If he didn't pay it, his contingent fee went down to 15%. It's not that he didn't have some incentive to pay it. The question is, did he have to pay it, and what happened if he didn't pay it?
But counsel, I'm sorry, because time is running out.
I'm
but
sorry, Your Honor.
On attorney's fees, the way I read this again is, it's not a reimbursement, it's a percentage?
It's a percentage.
And what is the percent?
In terms of
In
the
terms
deal,
of if they settle this case and they get a recovery, the attorney's fees come off the top.
The counsel fee, the lawyer fee, the fees for the lawyers they hire come off the top.
And how is it calculated? Is it reimbursement or is it a straight percentage of the recovery?
It's a percentage, it's 25%.
Right.
And the lawyers agreed to bear all of the costs of the case, except for expert witnesses, and they contemplated that the expert witnesses would only be paid out of a
So
recovery.
25% of the recovery, first 25% goes to...
To the lawyers.
The lawyers.
And then the 85% of what's left goes to the seller, goes right into that account, which is for the seller's account, and they come at the end of the waterfall. So whose interests are they pursuing here? This is what the distinction is between somebody who takes an assignment to pursue their rights and somebody who takes an assignment to profit from the litigation process.
Well, look, I can just interrupt because your time is up, but just this
Sorry, Your
question
Honor.
with the Chief Judge's permission. So it's clear that with that safe harbor, that the legislature is interested in, if not promoting, at least ensuring there are not obstacles to certain types of arrangements, correct?
Yes.
Okay, so these kinds of arrangements. So
Yes, Your Honor.
So, given the nature of the kinds of arrangements that the legislature is interested in, why does it require the exchange of cash or the payment when, especially in the financial center that we are in, individuals and companies come up with all kinds of complex financial structures, and there's leveraging going on all the time, and a promise can indeed have incredible repercussions, which is not necessarily about immediately, right, exchanging a payment.
Right.
But why do you need this payment? Because the statute doesn't say payment.
It
I
says
understand your reference to the bills, but the statute doesn't say payment.
It's true, the statute says purchase price, and
And one could certainly negotiate a purchase price that's lower than what the other person in this agreement thinks is the ultimate value, right? That's part of this negotiation.
Yes, yes, but you know, the legislature settled on $500,000. And it's not just the bill jacket, the memorandum, which says repeatedly, we're talking about a payment. It's also, there's an affidavit that they submitted on this motion from the sponsor of the bill, Assemblywoman John, and she uses the verb to pay, paid, payment 4 different times in her affidavit. That's their evidence that they submitted, and they're bound by it. But coming back, Judge Rivera, to your question, I believe
Why
that
is it so
the
obvious,
reason-
is it not in the language of the
the
provision
language of the-
itself?
Your Honor, the language of the statute is ambiguous. It is, because it says purchase price. All I can tell you is what the evidence in both the legislative history and the affidavit they've submitted says, and I can offer to you a rationale for it, so that...
It just strikes me, given the nature, and it'll be the last question, or rhetorical in some sense.
You can ask me as many questions as you like, Your
Well,
Honor.
the Chief Judge and everyone else may not think so. So the nature of the transactions that are being made possible or taken out from under the coverage of the Champerty statute otherwise, based on this provision, are in part exactly the kind where you might not exchange funds, but you might instead have these other kind of complex financial instruments that support the interest in the transaction. And that's why I'm having difficulty with your argument.
Your Honor, the problem is what the legislature wanted to do was to avoid litigation like this. They said, you shouldn't pay a bunch of money, $500,000 for a debt, and then be embroiled in litigation about whether or not there's Champerty. So there's no way, other than to have a bright line where it's like a mortgage foreclosure and somebody says, I paid, where's the check? And if you require a payment, and there's all the evidence there that you need to find that the legislature intended a payment, you have a bright line. You will never have litigation about this issue on these facts ever again. But can I come back to one last thing, and let me give you one
Very
cite for
quickly,
the
sir.
record, Your Honor, and that is to Mr. Lowe's testimony that it was neither a default nor a breach. And that is at page, hang on, I'm just sorry. It's at page 464, 461 of the record. And it's throughout his deposition. I asked him 3 different times, and every time Mr. Lowe said, it's not a default and it's not a breach. It's a debt that's due. But this agreement's governed by New York law and calls for litigation in the New York courts. If I say I'm going to do something in an agreement, but you can't sue me if I don't do it for default or breach, you don't have a remedy.
Thank you, sir.
Thank you, Your Honor.
Mr. Sabella, to your adversary's point about that it's neither a default or a breach.
Yeah, that's where I wanted to follow up. And there's nothing in the agreement that says you can't sue us for it. The agreement doesn't have, no agreement has to specify what your remedies are. If you promise to do something in an agreement and you don't do it, you get sued for it. And the agreement doesn't have to specify what the remedies are. And at A458 and 459, Mr. Lowe testified about this. And he said they have creditors' rights. We're in their debt. Now, I don't think he wanted to spell out, and I don't want to spell out a roadmap for DPEG for exactly how they should go after my guys to get the money. But the fact is, it's a debt, and they could go after Justinian, and they arguably could go after Justinian's principals.
What's the point
they
of
owe
saying
the money.
it's not a default?
Because they can't immediately take the notes back. If it's a default, they can immediately take the notes back. It craters the litigation, and our clients are completely out of luck, can't
So
pursue the
do
case.
you agree with your adversary that the language of the statute is ambiguous when it says purchase price?
I don't. I think if it had wanted to say paid, it would have said paid, like the previous version of the statute that they had under consideration and didn't adopt it. And I want to talk about that John's affidavit. That affidavit was submitted in the other case that I referred to between the parties, where in fact my client had paid the upfront money. So of course her affidavit talked about the money being paid. In that case, the money was paid, but she was not drawing a distinction between whether it has to be paid or whether a promise to pay is
You
sufficient.
know, you only got a second. The appellate division at the end talked about DPEG subcontracting out its litigation for purely political reasons. You should- you
Yeah,
should-
I would like to address that,
Yeah,
because both of the
address it.
courts below talked about the idea that if DPEG had sued on its own, that would have imperiled its existence. None of the documents and testimony said that. Again, a
Well,
clever
that doesn't mean
phrase
there's not a
by Mr.
political reason for subcontracting it out.
Not at all. The board actually authorized, and this is at A351, the board authorized the head of DPEG to sue in DPEG's own name. Obviously, banks don't like to sue each other. They don't like to do it in Germany. They don't like to do it in the United States. But they do it, and the board authorized him to do it. But he looked for alternatives, and he found one that he liked better. But that doesn't mean that...
Is it just a bank, or it's also a government entity?
Well,
That make it slightly different?
maybe it increases the reluctance, but it doesn't... The board authorized him to do it. And it doesn't mean people sue the government all the time. People that have businesses with the government sue the government all the time. So it happens. To the extent that stirring up litigation matters, and again, the amicus brief makes decent showing that maybe it doesn't, but to the extent it does, either this didn't stir up litigation, or at a minimum, there's a factual issue that it didn't stir up litigation. The last point I'd like to respond to is this point that it's an option. I don't consider it an option, because if we lose this appeal, the case is over. We still owe $1 million, and they can come after our client. I would expect that they would. They might put Justinian into bankruptcy. They might try to seize other assets that it has. They might try to go against the principals. If it's an option, you can't do any of that stuff. But Mr. Lowe testified here they could.
Thank you, sir.
Thank you.